Welcome to WAF. Entire nation is waiting with an bated breath to know what will be the judgment to be rendered by the Honorable Apex Court pertaining to the Chandrababunaidu's case with regard to interpretation of the provisions of Anti-Corruption Act, Section 17A, and also the scope of the Honorable Supreme Court under Article 136 and the scope and purview of the Honorable High Courts in exercising their power to quash FIR by invoking their power under Section 482. The main sum and substance of the allegation is the remand of Chandrababunaidu seems to be illegal according to the defense theory that the FIR was subsequently issued whereby the offence is said to have been committed or alleged to have been committed during period which is ranging from 2015 to 2017 and 2018, so on and so forth. But the FIR is registered in 2021 where Mr. Naidu was arrested. The sum and substance of the argument of the state is that the date of offence is the starting point where any offence, an FIR is registered belatedly also, the procedure which was contemplated on the date of offence has to be taken into consideration. Both arguments are equally appealing. It is, let us see how the Supreme Court will interpret, and there are chances that this matter may be referred to the full bench because it involves constitutional interpretation and also the binding judgment of the Supreme Court, Honorable Supreme Court, rendered in Lalita Kumari's case. Once the FIR is registered in a cognizable case, unless the FIR is registered, no investigation can be done. And there are fetters of power that even for the court not to interfere in an investigation under Section 156 Clause 2 of Criminal Procedure Code. But if the special enactment comes into play and the procedure contemplated in this special enactment with regard to investigation, inquiry and trial under Section 4 Clause 2 of CRPC, whether this has to be taken, if so, whether the said provisions or actions of the state are hit by Article 21, the procedure established by law, or another provision of the very same constitution, whether the offence has to be construed from the date of the offence. So there may be a very interesting judgment which may be rendered by the Honorable Apex Court. There are two possibilities which may happen. The quashment of seeking FIR by Mr. Naidu may be allowed on the ground of non-compliance with Section 17(1)(a) of Anti-Corruption Act. Thus, the FIR pertaining to Naidu may be quashed, or there is another possibility: the Honorable Court may construe from the date of offence the subsequent FIR registration may not be challengeable, and the date of offence will come into play. As such, the application filed by Mr. Chandrababunaidu may not be allowed by the Honorable Supreme Court. Let us wait for how the Supreme Court is going to interpret the law, because this will have an impact on our public servants who are also eagerly waiting for the outcome. If Chandrababunaidu goes away by this procedural irregularity, all the politicians will be very happy. But as of now, if the Supreme Court gives such a judgment, then none of the politicians can be arrested without seeking the permission of either of the governor or of the president. It will be very good news for the public servants, especially the persons who are in politics. Or if it is otherwise in public interest, if the application of Naidu is dismissed, then there will be lots of vigilant action by the proactive people waiting for changes and reforms in the democracy. Friends, kindly subscribe, like and share this video. Thank you.